Just you want to. No, I have only one submission. So far as Ambalal is concerned, the language is exclusively for trade and commerce. If your lordship see the entry, and that is how the Supreme Court interpreted it, saying it should be used on the date of the agreement for trade or commerce, not otherwise. Therefore, that judgment can't be simply brushed across the entire provision, saying all of it is covered by it. The second lot is shareholders agreement. As a conceptually, say shareholders agreement is any agreement among shareholders, and therefore a CCD also, my lord, is an equity instrument in that sense, and therefore being an equity instrument. And today the situation is the CCDs have converted into shares, and they become shareholders of the company. No, we have written an email to you saying it's all converted. You have refused to take it. No, I'm not converting. It is no. It was a conversion by period of time, by efflux of time. Conversion by efflux of time. The time period came to an end, it got converted automatically, and all other shareholders, not all of the investors. There's a clause. Lord, there is no other shareholder. Every three shareholders. There is a conversion with respect to all shareholders. One second. CCD grounds. Page 163, my lord. .1 is conversion. The email. Page 140. The email sent to them not upon conversion is at page 365. 365. Page 365. 365.
There are 3 CCD agreements.
I beg your pardon?
There are 3 CCD agreements.
Yes, ma'am. Yes, 3 CCD agreements. 3 CCD.
This conversion has been disputed by me in my pleading to the section 94. And I've said it's been forced upon me because in order to an attempt to render my section 9 purpose. So it is a matter of
Your agreement is a compulsorily convertible debenture. It has to be converted into equity.
But there is a mechanism under which.
So you may challenge the mechanism, but you can't challenge the fact that can't be.
No board meeting, no shareholder or board resolution passed to this effect. There was no prior inclination. And this is much after, almost 6 months after I filed the section 9, where they already have knowledge of my fact that I do not have any interest in proceeding with the arrangement, which is what I'm saying is there is a deep communication of decision of the contract.
360.
See, it's almost like trying to alienate a property, place it beyond my reach. This is the opposite of it, where you're transferring the property to me to render my entire exercise fee, right?
Where is the shareholders agreement?
There is no shareholder agreement. There is.
SHA, what are you referring to SHA?
It's a securities holders agreement. And that was.
No shareholders. What is shareholders?
The SHA is securities holders.
It's called.
That's the point I was saying.
Securities holders agreement.
It is a securities holders agreement with. That is what I was trying to clarify.
It's the same thing.
All investors and no one has been converted.
The provisions are, as you understand, it to be a shareholders agreement because it's all taken on an as converted basis.
No, no. In the side, we can look at the security orders agreement, who's defined as investor, who's defined as promoter.
The corporate governance, board meetings, all of them are
None
paid
of it
to.
has been placed into the section 9 code. It's all part of my allegations that there is no transparency.
No, there is this is an agreement with existing shareholders. Says so. So
Yes.
the top says between so and so and
You hold 500
shareholder-
shares already.
I have, that is in addition to the CCDs. It's not as
I
part
know.
of the CCDs.
Correct.
I have 5% shares under a separate arrangement. I'll show the PDF from the appellant's cases. Can you see paragraph number? It was an additional incentive given to me when I entered into the second and third CCD, where additional 75 lakhs was given. That is in addition and outside of the CCD arrangement.
Yes. Just to take down the appellant has filed the present appeal under section 37(1)(b) of the Arbitration and Conciliation Act 1996. Square bracket ANC Act impugning an order dated 2/5/2026 passed by the 16th Additional City Civil and Sessions Judge, the Bengaluru bracket, the Commercial Court, in arbitration application number 33 of 2025. Full stop. The respondent had filed the said application under section 9 of the 9 of the ANC Act, seeking interim measures of protection. Full stop. The don't say commercial court, I say district court. The district, the district court filed, passed an order dated 21/4/2020. Which was subsequently modified on 22/4/25. Passed an order dated 22/4/2025, which was subsequently modified on 3/5/2025. Full stop. Your date seem incorrect. The order is 2nd May. Order is 2nd
The
May.
original order.
Hmm.
2nd May,
2nd May.
2025.
2nd May 26 is the impugned order.
The modified order is 3rd May.
Modified order is 2025. The order shortly set aside is again the 2nd May 2026.
Which page is that order? Is it order on record?
Yes, no, that order is here. The order, my lord, of 2nd of May 25.
It's an order sheet you filed.
Yes, but it has it.
It's at running page number 106.
No.
Oh, this is, modified on 3/5/2026. 25. Full stop. The
First order is 21.
appellant had filed an application seeking further
106.
modification of the said order, which was partly allowed. Full stop. The while the Learned District Court had allowed and modified the and had partly released the appellant from its undertaking not to withdraw salaries, it also directed that the fixed deposit maintained by the appellant company be preserved. Full stop. The appellant contends that appellant number 1 is a startup, and it is stated that it requires at least an outlay of, currently it requires an outlay of funds of 16 lakhs, approximately 16 lakhs, to carry on its business operations. It's also contended that the import of the orders passed by the Learned District Court would in effect bring the functioning of the appellant number 1 company, or just say BPL, the functioning of BPL to a standstill. Full stop. It is also urged that since BPL is a startup, the stoppage of its functioning would effectively lead to its liquidation. Full stop. Next paragraph. Briefly stated, the relevant facts, context in which the controversy arises is it under. Just put the facts there. We'll dictate those.
Yes.
We'll give you the operative part. It's the submissions. One of the principal submissions advanced by the parties is the district court had no jurisdiction to entertain the application under section 9 of the ANC Act, as the disputes involved between the parties are commercial disputes, fall within the definition of commercial dispute. Full stop. This is stoutly disputed by the learned counsel for the respondent. He submits that the provisions of section 2(1)(c) of the Commercial Courts Act 2015 must be construed narrowly and does not extend to the CCD agreements. Full stop. He submits that submits a clause that the transaction between the parties, namely the CCD agreement, does not, or he submits that the CCD agreement does not fall within the definition of clause I of section 2(1)(c) of the subclause I of section 2(1)(c) of the CC Act. It also does not qualify as a shareholders agreement, as the CCD agreement is an agreement for subscribing to compulsorily convertible debentures and not to equity. Full stop. He also honestly contended that subclause 13 would also be inapplicable as it covers subscription and investment agreements pertaining to the services industry, but does not include a manufacturing entity. We submit that that appellant number 1 company, that BPL is a manufacturing entity. Is in the manufacturing industry. Is a manufacturing industry and not a service industry. Full stop. Next, he contends that although the CCDs have been converted to shares, the same is a subject matter of dispute between the parties. As the same as that such conversion is not in accordance with the agreement. He also contends that the investment, since the investment was made only in BPL, was only in regard with the understanding that it would confine itself to manufacturing activities. Its subsequent subsequent invention sending establishing cafes was outside the scope of their CCD agreement. Full stop. He has also relied on the decisions of the Supreme Court in Ammalal Sarabhai Limited versus KAS Infraspace LLP and another. 2020 15 SCC 585. On the strength of the said decision contended that the provisions of section 21C of the Commercial CC Act must be construed strictly in a narrow sense. Full stop. You also relied on the decision of a learned single judge of this court in Bhaskar Naidu versus Arvind Yadav. Polar neutral citation 2025 KHC 3634. And contended that share purchase agreement, that even right where the court, the single judge had held that a share purchase agreement would not be construed as a shareholders agreement within the meaning of subclause 12 of section 21C of the CC Act. So, the learned counsel appearing for the appellants encountered the said submissions. So we also pointed out that the section 9 application was not filed, was not premised solely on the CCD agreement, but it was expressly averred by the respondent that it was constrained to invoke the arbitration under the CCD agreements and the SHA. He pointed out that the SHA referred to the security holder agreement dated 4/9/2024, which was entered into between the company, BPL, its promoters, three other entities, including the Bonomi Investors Trust and the existing shareholders of BPL. Submit that even if it is accepted that the section 9 application was respondent section 9 was confined to CCD agreement, the same would clearly fall within the scope of a commercial. The dispute relating to the same would fall within a commercial dispute. We also submitted that that BPL was now established the phase and was always and that BPL had established the phase and thus it was erroneous to state that the respondent's investment is only in a manufacturing industry. This was confined to a manufacturing industry. Next paragraph. The learned counsel for the respondent also submitted that the scope of the present appeal was limited, as it was against an order dated, as the impugned order was only modifying an earlier order, which is not a subject matter of challenge in this petition. Any other contention that we have missed out?
No, I think.
These are the jurisdictions aspects.
Next paragraph. Then you just give a reason. And you say for the reasons stated above, we is find that the impugned order is unsustainable. It's not the Learned District Court did not have the jurisdiction to entertain a commercial dispute, and the disputes as articulated clearly fall within the scope of Section 21C of the CC Act. Disputes is noted above. Full stop. We also the view that the orders passed by the Learned Commission, the direction given by the Learned District Court, freezing the fixed deposits of the company in the given facts. In the given facts is would in effect would have far greater ramifications. Full stop. We may also note that the respondent's claim is in respect of a CCD agreement, which by its very definition requires to be is a debenture which is compulsorily required to be converted into a share. Full stop. Thus, if the agreement is implemented, the respondent would only be entitled to some shares of BPL. In any event, it will not be entitled to recovery of a sum of rupees, not entitled to the consideration that it is paid for the said CCDs, as the same cannot be redeemed. Full stop. We'd also ask the Learned Counsel as to how a claim of 1 crore, which is the consideration paid for CCDs, was maintainable. It submitted that the Section 9 was filed when no information as to how the affairs of the company, and therefore not made a claim in this regard. Full stop. On a pointed query from the court, it confirmed that there is no assertion terminating the CCD agreement. Full stop. In this view, we also find that the basis of seeking the basis for claiming for seeking interim measures protection of rupees for the sum as contributed for subscribing to the CCDs is vague. Is not don't say vague, is not specifically articulated. Thus granting interim measures of protection, such with the consequences as noted above, would in our view be unsustainable. The appeal is allowed in the aforesaid terms.
May I just request that all contention can get open, even if I wish to pursue Section 17 lending method. If I'm able to
Well, then I think
my primacy case for them to deposit the money.
we don't know without today. We asked you what is your claim. You said you don't know what your claim is because you don't know what the affairs of the company are. So what rights? All rights will be available to you. We don't know. We'll give out the reasons. Whatever foreclosed gets foreclosed.
At the time of filing the Section 9 pleading, I am under no obligation under law to articulate whether I'm choosing restitution or specific performance.
You have to articulate. You have to articulate it. Your interim measures of protection are the subject matter of dispute.
Yes.
Subject matter of the dispute, you have to say what your claim is. You may not ultimately quantify, but you have to say you're terminating the agreement, not terminating the agreement. Do you want shares or do you want money? If your claim was only for money, there's no question of protecting shares. It was no question of protecting or freezing the bank accounts of the company.
It was to the extent of my investment. Very well.
You argued before the.
Right.
Still number 20.
Yes, appear for petitioner in this matter. I have one submission to make before my land will put the subject.
I'm requesting for a. Oh, sorry. I'm
Will I have-
requesting for crossover.
Yes.
I have one submission minute in this matter. They have filed a memo for retirement minute.
I'm requesting for passover.
My lords, this is a matter of 1996, which was disposed of, my lords. The only reason why it was kept pending was the monies which were deposited. For the release of those monies, my lords, the state was given discretion to file an application.
Yes.
My lords, in 13/4/1999, my lords, the court said the writ petition is kept pending only for the purpose of monitoring the deposit of 2% amount and to appoint an independent body as stated supra for the purpose of framing of a scheme and utilization of the amount. In all other aspects, writ petition is deemed to have been disposed of, and in future no point on merit of the case will be considered as they have already been adjudicated. In view of the same, my lords, the court granted us permission for construction of primary health center in a particular survey number. My lords, that order of the Deputy Commissioner, my lords, the petitioner hearing challenges before the Karnataka Appellate Tribunal. The KAT, my lords, dismisses the same. The petitioner again approaches the writ petition questioning the KAT order. The Honorable
the
Court
petition-
initially grants a stay, my lords, then state files an application for vacating stay. My lords will get the order in page 148 of the second writ petition. My lords may kindly take that order, my lords. Page 148 in the 13256 writ petition, connected matter. Page 148, my lords, in the writ petition which is filed connected to the main matter. My lords, this is an order of vacating the interim order granted on the DC's order, my lords. My lords, the relevant part would be, it starts from page 152, my lords, para 7.
Yes.
My lords, upon a careful and plain reading of the directives issued by the division bench in WP zone, the court is of the considered view that the interim order granted earlier in favor of the petitioner requires to be vacated. The division bench has issued a categorical direction to the state to commence the proposed construction of the primary health center in survey number 21 measuring 6 guntas. Furthermore, the division bench has emphasized the urgency of the project by explicitly stating that the construction needs to be accomplished on war footing. In view of such clear finding directive, this court finds no justifiable reason to continue the interim relief granted as it would be in direct contravention of division bench. Additionally, this court takes note of the submission made by so-and-so wherein a specific undertaking has been provided that the state will not claim any equities in the event that the petitioner ultimately succeeds in the present writ petition. This assurance extended by the state serves as a significant safeguard for the petitioner, ensuring that his rights and claims as put forth in the petition are not prejudiced in any manner by the continuation of the proposed construction activities. It's also pertinent to emphasize that the rights and contentions of the petitioner shall be fully adjudicated in the pending writ petition, and the outcome of the same will determine the legal position. Until such adjudication is completed, the mere pendency of the petition cannot be a ground to indefinitely stall a public welfare project, especially when the division bench has also already issued express direction for its execution without delay. The key issue for adjudication is whether a Gram Panchayat's resolution can confer rights over state-owned land to the petitioner. The petitioner claimed title based on the resolution, while the state argues that the Gram Panchayat lacked the authority to allocate the land. Additionally, the petitioner contends the proposed primary health center was initially planned on a different survey number, but now being set up in survey number 21, where the petitioner asserts the possession of 22 guntas, now allegedly reduced to 17 guntas. The court needs, my lords may kindly mark this, the court to determine whether the Gram Panchayat had the legal competence to pass such a resolution, whether it created enforceable rights in favor of the petitioner, and whether the state's action in altering the land's use are legally justified. In light of the foregoing reasons and taking into account the unequivocal direction the division bench so and so, seeking vacation of interim order, accordingly the said application is allowed and the interim order dated so and so stands vacated. However, it is made explicitly clear that while the state is permitted to proceed with the construction as per the division bench directive, such construction shall remain subject to the final outcome of the writ petition. All these contentions what the petitioner is urging under this writ, my lords, is now still pending a consideration before the writ court. It can be considered, would be my respectful submission. They are protected by this order.
May I submit, Minister? So far as I am concerned, Madam, I was the petitioner for the petition in the first May petition, that is 31,815. That writ petition was filed in the year 96, Madam, and disposed in 99, as Additional Advocate General rightly said. Then subsequently, another person, there's connected petition. They have filed an application to come on record. And by mistake, probably notice was ordered to them because they themselves had sought to come on record. They have to question notice to them does not arise. But still, madam, we try to contact the petitioner. We are not getting instructions from him, and because it is in 96, he had instructed us. Therefore, we have filed a memo, for two reasons. One is I have been designated as the senior counsel in 21 minutes, and further, madam, my colleague, I think she has not filed the wakalat also, So therefore, if both of us are disabled to appear in this matter, we may be permitted to retire, and so far as the other petition is concerned, I am not concerned.
All right, just. So who's appearing for?
Lords, I am appearing for the Petitions Council.
In WP?
Lords, 13256 of 2025.
No, 31815.
There I was appearing, now I have filed a memo for retirement.
That virtually, my lords, is rendered.
For retirement, the same is, in view of the above, the counsel are discharged. None appears. None is representing the petitioner. In view of the above, none is present on behalf of the petitioner.
The writ petition is already disposed, Minister. In
Right,
34/98.
That's what it said. It's only listed.
Yes, yes, that's it.
So you said the list on dash. We have nothing. You have nothing else.
Nothing.
No, it's not.
Only if the requirement of money arises, my lords,
Only
then we
of-
will. It's protected, my lords. State is,
Why is it being listed?
my lords, that is because the
The
connected
reason why it is
matter-
listed earlier, the matters were listed, my lords. The difficulty was this. When the matter went before the learned single judge, the state government said that because of the directives issued by the division bench in the public interest litigation, where the permission is given to construct in this property, the court cannot go into this question because the stalling of the construction is going to impede with the orders passed by the division bench. That's essentially the argument advanced. Single judge was swayed with the arguments advanced, though those rights were not the subject matter of the list before this honorable court, and vacates the interim order. Inter alia, my lords, it may have given the other reasons, but the principal reason which has been assigned is this. Now I carry the same stigma in my writ petition if I go before the learned single judge that this is the stand which the learned single judge has understood. Res judicata applies at all stages. Can I just pursue, lords, may kindly see page 148.
No, this petition is not listed. There's no reason for listing it.
13256 of 25 minutes.
31815 of 96.
20.1 minutes is.
No, we are on 20. We are saying
Sorry,
20 must now be. There's no
Lords,
reason for listing 20.
in 20 there is an application which has been filed by me. Lords, may kindly have a look
That's
at
why.
that.
What is that application? Or recalling
is-
the order?
Recalling the orders.
Order dated
Lords, if the
25
state
April.
understands the orders passed by this honorable court as finally deciding the rights of the parties by virtue of the directions issued, saying that they are permitted to construct in survey number 6, Lords, then survey number 21, they don't have any case to pursue before any court. That's the stand which they had taken before the learned single judge. Lords, we have sought for recalling because as on the date when they had made the application seeking modification of the earlier orders, where they were required to construct the primary health center in survey number 58. Instead, they wanted to convert it in survey number 21. The entries, Pani, everything was standing in the name of the temple. Lords, it was to be brought to your lordship's notice that the property was still in the name of the government. That is something which was taken back, lords, or which was withheld. Now the parties who are before the court, there was a public interest writ petitioner and the state. These were the only two parties. Now, in relation to a property with which neither the state was concerned and nor with the writ petitioner was concerned, they come and say before the court that we want to construct the public health center in this property. Now, once the process is undertaken, I go before the learned single judge. Learned single judge, while vacating the interim order, says the division bench has said like this, therefore I'll not permit any writ petition being entertained as to stall the process because of the division bench's order. No, that was never the intention.
No, if you want application to recall, you consider it. That's the only application. Why it's listed.
Please.
Just say list on it.
Lords, they are finishing the construction, lords. Now nothing remains for me to pursue.
Will give you a date. Oh, there. You want to press your petition, no?
Yes, my lords.
Yeah.
Can I make an alternative submission, my lords, instead of the matter being kept pending? If your lords were to clarify that in that public interest litigation, the rights of the parties was not adjudicated. It's for the learned single judge to decide this matter independently. That will suffice the consideration. If the learned single judge takes a view of this kind, which is completely tangential to the proceedings.
He is protected by this order, interim order itself, where the learned
He's saying he's not. He's saying he won't press his petition to clarify. that
on
the orders were
all
not-
contentions can be kept open,
all
my
contentions.
lords.
It's not about all contentions, my lords. I want a specific, because that's the only gist of my argument, that your lordships have never decided upon the title or the rights in relation to the properties where your lordships have permitted this construction to go on, so that I can go before the learned single judge. I don't want that observation in para 6, my lords, of the learned single judge's order to again eclipse in the final consideration.
And they don't question the learned single judge's order. They don't file a writ appeal on that. That's still pending. If they had a difficulty with para 6, the petitioner has not questioned that order till today.
No, he seems to be, the impression is that this orders adjudicate the title as to that land. It doesn't.
Please.
You're not saying-
I leave it to my lords, but in the single judge has protected them would be my respectful
No,
submission.
single judge protects them otherwise. But
Please.
He's saying that this orders should not come in
Yes.
the way. To that you're not.
Court has just granted us release of money for this property. That's all is the order. Court has not decided the title of this survey number.
That's essentially what you said. As a matter of fact, their application says that we are the owners, my lords.
Yeah, we are the owners.
I'll just make
That's
a
the
mention.
reason why we have put up our construction.
You want. You want recall of the order of 25/3/2024.
Lordships. That is the order by virtue of which 58 was converted into survey number 21 of 6 guntas for only to the extent of primary healthcare center. There is another portion of it, my lords, with which we are not agreed.
And your main writ petition relief is what is the relief that you're seeing in the other writ petition?
Lords, the main writ petition is again the same thing, my lords, for recalling of the order, relying upon Shivdev Singh's
Petition,
case.
my lords, the seek
Substan-
recall of the order in
Substantially, the
the
relief sought in
PI.
application and the writ petition is exactly the same.
If my lord sees the order which they are seeking for recalling, my lords, there is
The applicant has filed the present application seeking recall of the order dated 25/3/2024, whereby the court had granted permission for the proposed construction of the primary health center in survey number 21, measuring 6 guntas of Golahali village, and survey number 156, measuring 25 guntas in Harinagra and Kothanaru village in Bengaluru South Taluk, in place of survey number 58 of Golahali village. Full stop. It was further directed, the court had further directed that the construction be accomplished on a war footing. Full stop. The grievance of the applicant is that the said order is being construed as foreclosing any dispute as to the applicant's right, title, or interest in the subject property. Conceitedly, the said order was passed on an assumption that the lands where the proposed construction is to be carried out were government lands, or the government had sufficient authority to carry out the said construction. Full stop. The import of the order is not to foreclose any title dispute as the subject land, as that were not the scope of consideration in the writ petition. Full stop. It's not necessary for this court to now examine whether the government has any right, title, or interest in the subject land. Full stop. We only need to clarify that the said permission is premised on the basis that the government has the right, title, and interest in the or authority to in the subject land, or the authority to carry on the construction as proposed. So this order will not preclude the applicant from agitating its grievance, albeit in accordance with law. Full stop. The application is it is not necessary for this court to recall the order in view of the aforesaid clarification. The application is disposed of.
Please. So it's just may say the writ petition to be decided independently, may not solve.
Writ petition. We'll say it now. You don't know your relief is the same, you said.
Please.
So Learned Senior Counsel in the next matter. Outside Learned Senior Counsel submits that in view of the clarification, order passed by this court clarifying the earlier order dated 25/3/2024, passed in WP 31815 of 1996. The petitioner's grievance in this regard is addressed. And the present petition may be disposed of, keeping all rights of the petitioner open.
Please, Vilas.
The petition is disposed of with the aforesaid.
Grateful.
With the aforesaid observations.
Grateful, my lords.
Now, just look for one recall. Just take recall 3 of 2024. It's only in that. And then the other part. So dispose. Just see what the application is.
Lordship directed me. Number 21.
Yes. Last 1 year.
My lords, may I request for a passover,
No, password.
please?
So it's number 22.
This is the matter where my contention was that
My lord,
ONGC versus Big Brothers would apply.
Your Lordship says
There
there
is
is
a
some
court-
inconvenience, a request for an adjournment in this matter, Your Lordships. The other side has also been informed that a request for an adjournment will be made, my lords.
No, this was- We partly heard this one.
Lordship had heard me on the last date. But
It was for
it
the
was posted for the other
respondents
side submission.
Please, my lords.
We also found out that the plus 91 security systems judgment,
Yes? Plus 91.
plus 91 security, very comprehensive in what Lordships have held that it's a commercial bargain. Contractual conditions which prevent claim of damages is a commercial bargain. That's the issue. I'll file a copy of it. My written submissions are also ready and a copy of that judgment. I can file it.
But on the next date of hearing, we may be permitted to file a written submissions, Your Lordship. Seek for a short
Always
accommodation.
subject to file it. This order sheets. But we had listed the 3 points also in the order. The only 3 points that you have to argue, we have listed this. We've set out in the order the 3 points that you have to argue.
Please, my lords.
A request for adjournment is made by the learned counsel. Respondent. Stated that the argue the learned counsel was to advance submission is unavailable. The request is parties are at liberty to file their written submissions.
22nd July.
Would Your Lordship note my appearance?
Yes, yes.
Still number 23.
This time, Mr. Kamath is also handed over. You handed over the written submission.
Yes.
Kamath has handed over written submissions.
Please.
As a respondent is also at liberty to. So, Kamath learned ASG is handed over.
Still number 23.
23, my lord, both affidavit and statement of objections are ready, my lord. I'm filing it. I'll get it filed during the course of the day, my lord. So ready for filing.
Learned counsel submits it. So learned AJ submits at the statement of objection. Seeks further time to file a statement of objection. He states they're ready. Will be filed during the course of the day.
The affidavit
also.
also.
Mr. Narsappa to be. Give it to Mr. Narsappa also. Give it to the learned amicus also.
Please, my lord.
Serve it on the learned amicus.
My lord, this is the affidavit is in relation to the delay, my lord, in complying with the previous order. Amicus was in relation to SOP, my lord.
That's right. When we hear it,
Please.
Please, my lords. On an earlier occasion, the clarificatory letter issued by the Minister of Mines was placed before my lords, which is ungazetted, which can never have the effect of notified gazette notification, because by virtue of section 3E I have called out in section 3E of the MMDR Act, which I may kindly be permitted to read, ma'am. Minor minerals means
has to be declared by notification. You're right. There's no dispute about that.
yes, my lord. Unless central government issues a notification.
No, we only have to see what the notification, existing notification.
Yeah. Now,
Not issuing a fresh notification. They're explaining what that notification.
yes. Till such a time, this will be laterite grade A will be minor mineral only.
So let's see the notification.
So it is printed in the book itself, my lords. It is at page number 162 of the same. I don't remember.
Page 160.
In my, it is 162. 162, my lords.
Lord, if I may
25
submit.
edition.
Lord, the last date we were directed to be implemented.
Yes.
Lord, we have sent a clarification to the state government. Satish.
This point is on a narrow thing.
Yes, no, I mean,
Your,
the threshold for bauxite is 20% of A203. So
no,
all,
you're saying that whatever you change, you have to change by notification. You can't change by a clarification. If you want to change anything, then notify.
no, it is by notification issued under the MCD rules.
Let's see the notification.
Yeah. By this letter, we have only clarified. But this letter,
Yeah.
other side got it.
This has been circulated on the last occasion, my lords.
This is really the issue.
True, my lord. Therefore, my lord, if there is a direction to the state authorities to draw sample and to determine on the basis of composition.
No, his argument is read the notification. Notification doesn't hold the aluminous laterite as 20%. It says bauxite is 30%.
It is at page number 97 of my writ petition, my lord.
Lord, 97.
Yes.
Lord, this laterite, depending upon the dominant mineral which it contains.
That's right. So
If the A203 is 20% and above, then it becomes bauxite. Now, in this case, that exercise of finding out what is the percentage of aluminous laterite has not been done. And that was the direction which your lordships had issued in the earlier order.
no, let's see. If you look at the bauxite one,
Yes,
as a notification, that's at page 97.
yes, Lord.
It says for aluminous laterite, it is AL203 is 20% minimum.
Yes.
So if it is less than 20%,
It is not bauxite.
it's not bauxite.
It's a minor mineral.
Even 20%, it is not
Yes.
bauxite.
Yes.
Minimum is 20%, so 19.99, it is
Yes.
bauxite. It is not bauxite.
Yes.
Then it comes to, for bauxite, AL203, 30% minimum. That is the one that was creating the issue. What will you do if your aluminous 1 and 2 seem to be, so their argument is that if there is a silicon there present in the mineral, then your to become bauxite, you have to be 30% minimum. If there is a 7%, if there is silicon in that mineral, then your 20% doesn't hold good, it becomes 30%.
Yes.
Now you look at your clarification.
Lord, in my clarification, Lord,
Same line as you've used.
would your lordship?
Sub 3 last line.
Yes, Lord. If I may read para 3, it is last line. It identifies different. It says, as per the IBM, the IBM has notified the threshold values of various minerals in accordance with 12.6 of the MCD rules. As per IBM notification, so threshold value for bauxite are aluminous laterite A102 is 20%, bauxite A203 30%, and SA02 total 7.3 is max.
What is 2? If you're only saying aluminous laterite is 20% is the minimum, then
Yes.
what does 2 do?
No, the aluminous laterite would be present in laterite. So the product that the petitioners is.
Laterite. Laterite is a stone, is commonly understood.
Yes.
A building stone with the.
Yes, yes.
According to you, if it is laterite is more than 20%,
Yes.
20% or more, then it is bauxite.
Yes.
That is AL203. If that is correct, then what is the need for 2?
No, then it may not fall under laterite. Please see para 5.
Yes.
However, it is pointed out that the National Mineral Inventory chapter on laterite explicitly describes laterite deposit based on their dominant extractable minerals, such as aluminous laterite, that is bauxite, ferruginous laterite, iron ore, magniferous laterite, which is manganese ore, nickeliferous laterite, nickel ore, and chromiferous laterite. So the bauxite doesn't fall here. Laterite is identified in 5 different categories based on the dominant mineral.
No, here dominant mineral is no issue. This is only aluminum. You're talking about bauxite, this is aluminum ore. So you're looking only at Al203. This is aluminum oxide is all that you're looking at. AL2O3
Yes,
content.
yes.
So AL2 content has to be determined. What
Yes.
is the content of AL2?
Yes,
What is it? 30% or 20%?
20.
Then what is the 30%?
30% in bauxite, not in laterite. Because kindly see, it says bauxite, it doesn't say aluminum laterite. It says bauxite.
No, both are bauxite.
No.
You see, the whole mineral is bauxite. See,
Laterite, if it contains more than 20% of aluminous laterite, then it becomes bauxite.
And
Then it will become a major mineral.
then
If laterite
Now it-
contains, I'm sorry, please?
if your bauxite means Al2O3 content has to be more than 20% in laterite, it becomes bauxite, according to you. Then what is bauxite? Both are bauxites.
Both are bauxites.
So see, the mineral is bauxite.
No, the first one is laterite becoming bauxite because of its high content of aluminum laterite.
And what is the next?
The next one is bauxite. It identified as bauxite.
And bauxite is aluminum content of
30% and more.
Al2O3, 30%.
Yes, 30% more.
So
So the difference is 10%.
the laterite doesn't have Al2O3 more than 20%.
But our stand is 20%. If it touches the 20 threshold is 20%.
We'll have to educate us a little more that what are the difference between the two.
Very well. I'll get instructions.
You'll have to ask or rather ask some expert to join
Yes,
in to tell us
Yes.
what is it the meaning with two. Otherwise, the second one is not meaning.
I'll
If you
follow that.
accept your first, then the second has no meaning.
Yes. Okay.
It ceases to be a bauxite.
Well, would your lordship please have a look at para 7?
Yes.
Furthermore, IBM notification established threshold values for bauxite in two distinct categories, aluminum laterite and bauxite, stipulating a minimum of 20% A203 content for a laterite to be classified as bauxite.
That is per se opposed to law. Because I would be submitting, my lords. The first in the bauxite mineral definition, small I1 says aluminous laterite minimum of 20%. There is no maximum limit. It can go up to 100%.
Yes.
The second one for bauxite, 30% is minimum,
Yes.
and silica content should not be more than 7%. That is the deciding factor for bauxite. If silica content is more than 7%, it can never be called as bauxite. That distinction I would like to place before my law.
We'll get some experts.
And that's the reason whatever has been mentioned in this 7th paragraph of this clarification letter is without the authority of law. Because this person who has issued this has no legal status by virtue of gazette.
All right, we are only interpreting this. So they'll have to, the second limb, that's what we said, silicon they'll have to figure out.
Yes, because why I said the impurities in the first should not be there. It should be 100% aluminous content.
No, not 100%.
The silica is
has
an
to be laterite.
impurity.
It is laterite. So according to you, this can only be read as that if there is any silicon content in the
In laterite.
in bauxite. If there's any silicon content in laterite, it's not bauxite. That's a short interpretation.
But that item number 2, why they included, I'll verify.
That's all you have to find out.
I'll
Because
possibly see if I can get an expert.
But till such a time the order passed by my lords on an earlier occasion, that benefit may be extended to me also, my lords.
so we have to finally decide it, because otherwise you'll be.
The thing is, by virtue of this order, so many others are enjoying the benefits, and I
That
am
was
to
the
tell
order without this clarification. Now the clarification is there is something more to it. Then otherwise they were saying that it is. But we'll examine. We'll put it on next week.
Please,
Just
my
get
lord.
the short. It's a short question.
Before one word, my lords, the threshold value which learned the senior has submitted, the minerals evidence mineral contents rules, section 3E defines the threshold value, my lords. That is important for my purposes. I may kindly be permitted to read.
You tell them so that they can take instructions also,
Please.
which is the one that you're referring.
The section 3, subsection E of Mineral Contents Rules 2015.
Which page is in this?
It is at my book, it is at page number 337, my lords. It is not there in that book. MMDR book must be separate.
We have MMDR.
Yes, ma'am. MEMC rules. Mineral evidence and mineral contents rules.
Page number. Definition number 4%. Or not subpage.
Shall I read? Shall I read?
No.
Threshold value of minerals means the limit prescribed by the Indian Bureau of Mines from time to time based on the beneficiability and marketability of mineral for a given region and given time, below which the material obtained after mining can be discarded as
There's no
waste.
dispute about that.
No, I will go because only for better appreciation, threshold value has referred to.
They're not saying that below threshold value is bauxite. Please, question is, what is the threshold value? It is 30% with silica, or is it
True, my lords.
50% without silica? That's the only question that is to be.
Please, my lords.
Just put it next.
It is
In WP number 17983 and in WP number 17359. These are situations where they have not denied the access to parameters portal without having ascertained any kind of analysis on the mineral.
So that they'll do. Analysis of mineral they'll do. They're doing.
I'm not able to get any FDP issued in.
That's in both. For those that are less than 20%, there is no dispute. For those that are 20%, you get analysis. You can't hold them. No. You have some of these matters you've not done an analysis, and that you've stopped by saying till we now because of the circular we will do them. Do it in those that are out below 20, at least those release. There's no dispute about below 20.
We'll examine and secure instruction by the next date of hearing and make my submission.
My lordship, there's no analysis done on any of the mines, my lord.
Plus, in the meantime, there might be directed to grant access.
You have it next week. They'll take that. Just said the principal question involved in the present case is whether laterite which has a min Al203 content of below 30% and SiO2 content of below 7% would can be classified as bauxite. Of the threshold value of the minerals is as notified under threshold value of the of bauxite as notified under the notification dated 25th April 2018 is set out below. This is at page 97. Just take one. Only bauxite, that's serial number 2. Full stop. Whilst the respondents contend that if Al203 that laterite with Al203 content, which is 20% or above, is bauxite. The petitioners contend that an aluminous laterite the threshold value for aluminous laterite is Al20 is mineral with a Al203 content of minimum 20% if it does not contain any silica. Bracket SiO2. Full stop. According to the petitioners, if the laterite contains silica, then the minimum Al203 value is specified as 30% and not 20%. The learned ASG seeks time to take instructions in this regard. Next paragraph. It is also contended on behalf of the petitioners that no analysis whatsoever is being carried out by the state, and yet the access to portal has been denied. It is submitted that in many cases, the aluminous laterite content is less than 20%, and there is no dispute that the same would not qualify as bauxite. Learned AG seeks time to take instruction in this regard as well. List on.
22nd July.
Please, my lords.
Seal number 25.
This matter relating to reservation limits
Yes, we'll have to start this.
today listed to be hearing.
You're all ready?
Please, for the state, my lords, a special counsel, Raghuram Kumar sir has been appointed. They are appearing, my lords, for the state. I'm appearing for the public.
It is the main contesting party.
Please, my lords, state is the main contesting party. My lords. Sir is representing state. My lords.
All right, then we'll.
I think
have it after
pleading,
lunch.
We are filing the objections.
pleadings were not complete.
Pleadings are not complete. In one matter, we are filing the objections. In other matters, we'll.
That you will read it in all matters.
Sorry?
That will have to be read in all matters. Yes.
No, there are some peculiarities in the case of the party in person. It needs a separate counter.
No, whatever you have to file because you have put it down.
Yeah, we'll do that. We'll do that.
Last occasion, long back, this court division bench had directed that the pleading should be
Which one
completed.
you're filing your objection in which?
25.1.
All right. Who's appearing in 25.1? WP 3145 of 2023.
25.1.
Is there anybody appearing in WP 3145 of 23?
Prithvish MK.
That is a PIL, my lords.
Not notice, we are talking about the petitioner. We are not talking about this.
Mr. Prithvish is appearing in that, my lords.
Prithvish. Okay.
Prithvish.
Yes? So we'll start after lunch. His pleading is complete. They have filed the objection. You can take it and then you can start. You can start
May I make one submission?
You can file your objections during the course of the week in all matters.
Please. In 1 week, we'll file in the other matters.
During the course of the week file, this is not going to get over. Let them start. And you address your arguments, but we have to.
Very good.
Come after lunch.
There is a state petition also. That they may start.
No, there is no state petition.
State's petition is there, my lords, 25.2. There, my lords, the tribunal has set aside the promotion in excess of 50%.
That's the principle.
That's a consequential. What had happened there was the notification in respect of one notification was challenged on the ground that it is in excess of 56%. But what the tribunal has done is, tribunal says that under the ordinance, a roster points was issued, additional roster points. Now, under the act which replaced the ordinance, the savings clause is not noticed. Only the notification is set aside. That is what has been done by the tribunal. But 56%, my lords, there is an incidental finding that it is contrary, my lords, to Jayashree's case. So therefore,
it got
So
connected.
obviously you are challenging that finding.
We are challenging that finding.
So you can start. On 56, you can start. That's a key issue.
Please, on 56 minutes, we are defending that in the connected matters because there the principal challenge.
Issue is only this.
Please, but it is by virtue of a legislation. Act has been challenged in the connected matters. In this matter, there is no challenge to the act.
In any case,
Please, but the principle is this.
If you're defending it, we only want to know who will start the arguments.
I think the petitioner
I will,
they should start.
there is no problem, but in my case, they have not filed the objections.
That's all right. On this
I
question,
will
you
start,
find it
but
in
they have
one
no
that we
difficulty.
accepted in there. On them, we can start. After lunch, start.
Only one, we have raised a preliminary objection
Yes.
because none of these petitions, there is any challenge to the 56% reservation. There is a challenge only to the act in respect of scheduled castes and scheduled tribes, which has increased the percentage of reservation from 15 to 17 and 3 to 7.
Consequential increase of 56. That's what they're saying.
But there is no challenge as such for the 56. Say a
So why
preliminary
are we going around the point? Is this not the subject matter of challenge? That's what we have to decide, whether you can cross 50.
No, act is under challenge. I respectfully submit. Act is under challenge.
Yes.
And
But there is you please consider on the footing, there is a specific challenge that you can't breach 50%, which is a key issue here. Even in your petition, that's a key issue. You're filing, challenging that finding. Not good enough to say the act is not challenged, but 56% is challenged. That's very much your petition. Unless you want to withdraw your petition, don't want to press that.
we are pressing it.
That automatically will bring your act into question which you have challenged. Come after lunch.